It never happened before, so hopefully he'll be back. Go ahead and have a seat, I guess. Well, good morning, and oh, there he is. Sorry. The only person who's actually indispensable, and he's not here.
I'm the only one with the gavel. So.
All right, go ahead and gavel us in.
All right.
All right, well, welcome to the Ninth Circuit. There's a little bit of a rocky start here. Judge Tallman and I are very pleased to welcome our newest colleague, Judge Tung, to his first oral argument, I think. So I don't know if you guys someday will be able to say that you presented the very first oral argument to the legendary Judge Tung at some point. So you should write this down in your memoirs. We have several cases that have been submitted without argument this morning, and then we have, I think, 3 cases for argument. Our first case for argument is United States of America versus Bragg. And I believe, Mr. Crowley, are you going to start? All right.
Yes.
Please state your name and let us know how much time you want to try to reserve for rebuttal.
I'd ask to reserve 3 minutes for rebuttal, please.
All right. You may proceed. Thank you.
Thank you, and good morning. May it please the court. Your Honors, we contend here that the sex offender treatment ordered was not reasonably related to the sentencing statute factors, as opposed to an order that would have only ordered general therapy and counseling. And when I was preparing for this argument, an analogy came to mind, which would be, say, as opposed to the pimping type of action that Mr. Bragg engaged in, if he was instead having a 17-year-old sell drugs for him, and he was taking the money from the drug proceeds, maybe giving her a little bit, and keeping the rest for himself, he would still have the same power and control dynamics. We would still have the issue of the person being a minor. And I would contend here that his actions, where there's no evidence before the lower court of sexual interest in this 17-year-old.
Who fathered the child?
For the underlying...
She was pregnant, was she not? The 17-year-old that he was running?
I don't believe he... I
thought I read somewhere in the papers.
Yes, I think I know what you're thinking of. There was a revocation for a second pimping and pandering incident from 2024 or 2023 where his girlfriend, who was an adult, ultimately had a child with Mr. Bragg. But the underlying victim in the original case that caused him to be on supervised release, I don't believe he's the father. And I
But wasn't he arrested in Riverside County on charges of harassing a 13-year-old?
And a state court case, yes.
So I guess where I'm going with the questioning is, why is it an abuse of discretion for the district court to conclude that he needs some type of sex offender counseling if he's pimping out underage women?
It's the lack of personal sexual interest in or personal sexual actions.
But he's promoting and aiding and abetting prostitution by minors. That's the concern I think that the district court had. And frankly, it's a concern that I share if I were the sentencing judge.
The issue is where we have these generalized bases, such as the criminal history dating back to him being a minor himself, such as issues with his own mother not being present for his upbringing and being raised by uncles and fathers and being abused, and those such issues, and where we have issues of him, as the oral report from the probation officer said, where he was psychopathic. My position is that those all indicate a need for that general treatment, but there's not something where he's on that level of needing sex offense specific treatment like somebody who's viewing child pornography.
As I understood, the district court basically ordered whatever treatment the mental health professional recommended that would be helpful to him. And that requires a psychosexual evaluation, does it not? And apparently that had not yet been completed at the time of sentencing. Do I understand the record correctly?
I believe so. Well, I'm sorry. At the time of the original sentencing, it had not been completed, but at the time of our revocation sentencing that's being challenged here, it had been.
And what did the mental health professional recommend that he needed
They
by way of treatment,
they recommended that he continue with the sex offender treatment.
which was consisted of what? Counseling, group counseling, individual one-on-one counseling?
Well, the order, we didn't receive the
actual
the
report.
report in the record, so the specifics are not there. But the court's order indicated physical testing, psychosexual testing, those kind of sex offender specific tests, and that's what we're after here with this objection and appeal. Is
Well, I guess where I'm going with the questioning is the district judge is not a clinical psychologist or a psychiatrist. So what is improper about ordering the defendant to comply with whatever treatment a professional directs who is conducting the psychosexual evaluation? To me, that makes perfect sense. I'm trying to understand your position that somehow that amounts to error.
our conclusions from the report, as relayed by the probation officer, are that he's psychopathic. They don't inform
That's a pretty serious diagnosis if that's what the mental health professional concluded, is it not?
Yes, and we agree with generalized treatment and therapy being appropriate here and reasonably related to the sentencing factors.
So are you arguing that the district court should have countered the recommendation of the mental health professional as to what treatment was appropriate for that diagnosis?
I argue, number one, that the district court should have reviewed the report.
Well, we don't know that he didn't. It's just not in the record, right?
The only
thing the record shows is what probation recommended.
Right.
Yeah.
I think you're right. I don't think the record has the judge saying I did not review the report.
Correct. So we don't know.
Right.
But then I go back to my earlier questioning about his criminal history. I mean, this guy is not a first-time offender. He's got a long rap sheet involving sexually deviant offenses.
I think that's where I quibble with the court, and that's the point that distinguishes this
Well, he's
from.
30 years old and he's never had a legitimate job. So where do you think he was making his money? I read it off the backs of these women. That's how he was making his money.
Yes.
Okay.
But I see why you draw that conclusion. But my point is
the record supports that conclusion.
My concern is that it's where we talk about this sex offender specific treatment with the specific physiological testing done with that. These are things that are geared towards people who personally have the sexual interest.
So you do want the district judge to basically disagree with the recommendation of the mental health professional and designate a different type of treatment? How is the district court in a position to do that? We're not trained psychosexual evaluators.
I think the district judge, based on the conclusions that were drawn of being psychopathic and knowing that he had not had sexual interest against any person, I think the district judge should have reviewed the report and then seen exactly why to be able to conclude that it did reasonably relate.
You're asking us to speculate on the basis of unknown evidence and conclude the district court abused its discretion. Is that your position?
I'm asking this court to remand it to the district court so that the district court can review the actual report that underlies these conclusions and ensure that it does reasonably relate.
But on the basis of wholly speculative assumption that somehow that report is not going to substantiate the recommendation by the psychosexual evaluator.
I don't know that it's speculative. It's more about having...
Well, it has to be because you don't have the report and I don't have the report.
Right, but the lack of report in the record, the lack of evidence before the court of the report indicates that there has not been record support for it reasonably relating to the sentencing
based
factors.
on his background, which it is in the record, the evidence points the other way. My concern is you've got nothing to put your finger on to dispute.
As I understand, your argument is that, well, yeah, sure, he's involved in all kinds of sexual business, but there's no evidence that he's personally sexually deviant himself, which is an interesting. Maybe if maybe we'll have you reserve your time and hear from the government if you want, and then you can.
Sure.
And I think that is that a.
That
am I accurately?
Yes, the
Yeah.
lack of personal interest, the lack of personal action against another person for his own sexual gratification or interest or
But
desire.
we do have, and we'll hear from you when you get back up. But and I'll make sure you have enough time. But we do have evidence that he's in this business, and we have evidence that he's pimping his pregnant girlfriend at some point. Boy, it's hard for me to see how that not enough for a judge to decide we need to maybe order whatever treatment a expert on this thinks. You can respond if you want, but then I'll give you time afterwards too.
I think we're just missing that link where if he has his own non-criminal sexual action with the girlfriend, which obviously resulted in her becoming pregnant, that's not the crime, so to speak. The crime
he's pimping her, and I would say most people would say that's a criminal sexual action with your girlfriend.
The action of pimping is, but what we have is this treatment,
and it's pimping is sexual.
Well, I think that's the distinction that I draw with the argument is when
pimping is just business.
Is as the evidence showed his actions.
That's what he says, but he could see where maybe an expert would think otherwise, and why the district court judge might think otherwise here. And I guess to Judge Tallman's question, you're basically asking us to sit here and second guess that, and that's what I'm struggling with.
Well, not only that, not second guess, but ask the judge to rely on the actual report as opposed to the bare bones conclusions, and that's why I got into the delegation concerns of the separate section of the argument and the part about the argument about it being reliant on unreliable evidence, where we just have this accusation but not the actual report itself to back it up, so to speak. And so with this record, I believe that we've fallen short of showing that it's with reliable evidence showing that this was reasonably related to those factors.
Counsel, I think you have a stronger argument on the delegation point. So can we really quickly, how do you distinguish United States versus Reardon, Ninth Circuit case 2003, where the court had ordered the defendant there to participate in a psychological or psychiatric counseling and or a sex offender treatment program as ordered by the probation department? How is that distinguishable from the condition here, which seems very similar? Complete a sex offender evaluation, which may include periodic psychological testing at the direction of the court or probation officer.
Thank you for that question. The big distinction is in our probation condition, we have, just following the part that Your Honor read, the word if.
So that makes all the difference, the word if.
That's our position, yes, because if ordered, passes the decision off to somebody else besides the district judge. In Reardon, we just have as ordered.
I thought the order was, if the psychosexual evaluator determines that this course of treatment is necessary, you're ordered to complete it. What's wrong with that? That's the district court issuing an order to the defendant as a term and condition to complete whatever treatment the mental health professional prescribes.
Because it leaves the decision of whether or not treatment is to be given up to if somebody else determines it's necessary, as opposed to the district judge.
A trained expert on psychosexual evaluations, which the district judge is not.
I think what the right way to do this to avoid delegation would be for there to be an evaluation and that to be given to the court.
But
and then
counsel,
the court,
as you know, psychosexual evaluations can take months to be completed just because of the volume and the shortage of examiners that are available. It is not uncommon for our district judges to be sentencing sex offenders without a completed psychosexual evaluation report.
I honestly can't say.
Well, I'm telling you from my experience of doing this for 25 years, that's what I've seen over the years.
My concern is that simply because it's not simply, but with those issues of it being slow, with those issues of it being a process, I don't know that means we can do away with the delegation objection for those reasons.
Counsel, what if instead of the current phrasing in the special condition, it said complete a sex offender evaluation with all the testing, and then it says participate and successfully complete an approved state certified sex offender treatment program at direction of the court or probation officer. So you remove the words if deemed necessary by the treatment provider, substitute it with at the direction of the court or probation officer. Wouldn't that be materially the same?
As Reardon?
As Reardon.
As Reardon?
If we remove the word if, but
Right. We substituted with at the direction of the probation officer. Doesn't that inherently give some discretion to the probation officer? And haven't we already held in Reardon that was permissible and not a delegation concern?
well, I think in Reardon, with that phrasing, they were just left with the sort of where and when issues with the as directed. But I think that what you have proposed as a modification, Your Honor, is changing the meaning of the condition. Once we remove the word if, it changes it to an as directed, and all that's left is for the probation officer as the wing of the court to
So
determine.
that's
the
what I
where and
understood
when.
your argument to be, but practically speaking, maybe there's if makes a huge difference constitutionally or something, but practically speaking, it doesn't seem like there's much distance at all between the difference between saying, as a judge, do whatever treatment the person, the expert says you need to do, which could be none, right? But yeah, I'm ordering you for treatment of the type and to the extent that person thinks you need, and in theory it could be none, versus saying be evaluated by that person and then do whatever treatment. And the latter is closer to our case, and you're saying that's not okay because the on-off switch of the treatment is being turned on or off by the expert, not by the judge. Whereas if it just seems mostly, if not entirely, semantic to say, okay, you're going to do treatment, but you can do as little as the expert thinks you need, including down to 0. But that's okay under Reardon. I'm struggling with. I understand the difference, like logically, between saying you're going to do treatment, but this part of the person is going to set all the parameters, including the amount of it, versus saying how this person evaluates you and do whatever treatment they say to do. I understand theoretically there's a difference, but practically it's hard for me to see what the difference is. And then it just feels like we're just sending this back for pure semantics.
I see what you mean about the lack of a practical difference. My concern is if the judge were to order if the lower court judge were to order only that treatment at the direction of the as recommended by the evaluator, that would be an order that needs to be supported by the relevant 3553 factors, and without the evaluation underlying it, we lead to a point where it's not reasonably related because
So I think you got two arguments. This is sort of responding to what I would put in the bucket of, I'll call it the Judge Tallman concern that we were talking about earlier, which is there's just not enough here to support sending for treatment. We want to remand for that. And the other is this more this textual idea that you have to have the judge has to make the decision, and here the judge did not make the decision precisely the same way they did in Reardon. And those are two different arguments. Why don't we do this? We're taking you way over. We'll let you come back up and respond to the government's position. But I think those are the two positions I'm seeing here.
Thank you. Yes.
Maybe we'll put 2 minutes on for him when he comes back up.
May it please the court, Daniel Zip on behalf of the United States. Your Honor, starting with the first issue that you identified, the district court was well within its discretion in imposing a sex offender evaluation condition in this case. My defense counsel sort of used
What do you think of the idea that, well, he's in this business, he makes money from sex, but he's not really himself somebody who needs treatment because there's no evidence that he himself has attracted the minors, he just pimps them out.
A couple responses. One, the guidelines specifically call for the condition based on his offense of conviction, which is sex trafficking of a minor. So the fact that it doesn't fit within the category of someone viewing child pornography or a child molester, it's still within the guideline. And so there would have to be something exceptional about this case to take it out of the guidelines.
Could there be treatment? And I'm not super familiar with the different types of treatment, but it could be treatment tailored to somebody who, if it really is true that he himself has no attraction to minors, he just wants to make money off of them. Is there treatment for that type of person that says, you shouldn't do this?
Yes, the condition was broad, and as the 10th Circuit in Williams considered the same issue as to whether pimping can require sex offender treatment. And what they said in that case, they said that the sex offender treatment can destroy the cognitive distortions and thought processes that objectify sex and women. So even if he had no personal interest in the women that he was trafficking, it's still sort of antisocial behavior that could use treatment to correct it. But I would push back on the idea that he was totally removed and this was entirely a business proposition. I mean, if you look at his history and characteristics, he has one conviction from the state court before the offense at issue here. He was in a relationship with a prostitute in that offense. When he was out and on parole for that conviction, he then commits this offense with a 17-year-old. The 17-year-old's mother was looking for her, said she was a runaway, saw pictures posted online. This was a defendant who was taking nude photographs of a 17-year-old, posting them, selling the victim for money. That's very troubling behavior. And if you look in the PSR, the victim of that offense even told the arresting officers that she was dating Mr. Bragg and claimed not to have been having sex with him. But then you look at after he got out, he was prostituting another woman who he was in a relationship with, who was actually pregnant with his child. So the totality of his history and circumstances doesn't support the idea that he's just this sort of businessman unrelated to any sex offense element. So based on that, and based on the need for rehabilitation, the court had to consider the fact that this defendant had initially agreed to sex offender treatment, had then refused to speak with the polygraph examiner, and who even the treatment provider had indicated was not amenable to treatment, but was still worth another shot, essentially.
So what about this other concern that Reardon is close, but not exactly, because in Reardon, you're ordering treatment, the judge is ordering treatment, and then the type and extent of the treatment is being set by the professional, whereas arguably here, the judge is saying, if the professional thinks that you need treatment, you have to do it.
Right, and there's nothing wrong with that under this court's case law. What is that it has identified as the delegation problem is when the probation officer is allowed to determine the punishment. In Esparza, it was the probation officer was allowed to decide whether the defendant would have inpatient treatment or outpatient treatment. And this court held that forcing someone to go into this custody.
To put it in, to use an analogy, incarceration, if a judge said you should, said you need to be incarcerated for, and your good time credits will be figured out by somebody else. But if your judge says, I'm basically giving you over to this person and they will decide if and how much you'll be incarcerated, that would be a problem, wouldn't it? Or?
Yes, if the court in this case had said.
And that's the argument here, is that you're saying, in theory, that he could be evaluated and the conclusion could be that there need not be any treatment. So that, there's a logical aspect to the fact that the judge is not even ordering treatment.
Yes, although the court in Wells made it clear that as long as the court's determining punishment and determining what the conditions are, the details of where and when the condition will be satisfied can be left to probation.
Counsel, but this is no mere detail. In United States versus Hohag from 2018, we said, quote, sex offender treatment imposes a very significant restraint on liberty. And what this condition does, as I read it, the district court has not imposed the condition itself. Rather, it has delegated that determination to a probation officer. It says, or a treatment provider. It says, if deemed necessary by the treatment provider, then the sex offender treatment program shall be carried out, and that the defendant will be subject to that program. Isn't
Yes.
that a plain delegation problem?
No, we don't believe so, Your Honor. And I think the difference is the treatment might be sort of intense, but it's different in kind from what the court found to be punishment in Esparza, which is going essentially back into custody at the discretion of the probation officer. This court has repeatedly held that the type and number of tests that a defendant is subject to can be, the probation officer can decide the type and extent of sex offender treatment. And as Your Honor noted in Reardon, the court specifically said that the psychological testing and or sex offender treatment as ordered by the probation department.
But there, I mean, it could be a matter of just semantics. But as I read Reardon, it doesn't contain the conditional language of if the treatment provider decides whether treatment is necessary. It says the district court has ordered Reardon to undergo treatment, and the details will be left to the treatment provider to delineate. So the words, if deemed necessary, to me, might make a significant distinction here.
I don't read Reardon in exactly that same way. I think when it says psychological testing and or sex offender treatment, it is giving discretion to the probation officer to decide either he gets sex offender treatment or he doesn't. And it falls within that range of sort of implementing the details of where and when the condition is applied, as opposed to the narrow class of cases that the probation officer has essentially said, you decide when he goes back into custody through inpatient
Counsel,
treatment.
can I ask you?
sat on the panel in Reardon, and I remember the facts of that case very well. It's probably one of the most horrific sex offenders I've seen in my years on the bench. I mean, this guy was basically fantasizing about kidnapping and sexually torturing and murdering children. That's very different from the facts of this case. But even in that case, we said you have to comply with the evaluation and then whatever recommendation the treatment provider provides. And I don't understand why this is any different from our decisions in Stevens and Fellows, where we're ordering drug treatment based on a drug abuse evaluation and then whatever treatment the evaluator prescribes.
Well, I agree, Your Honor. I think it's only in that narrow case of punishment in the form of inpatient treatment or, I think there's psychotropic drugs that the court has held
I mean,
across
sex
the
offender
line.
treatment is on a continuum. I guess on the one end of the continuum, okay, you go to counseling sessions and you maybe meet one-on-one. On the other end of the spectrum is what you just mentioned, psychotropic medication or arousal testing, that sort of thing. And we're waiting for the professional to conduct the evaluation and decide exactly what treatment this particular offender needs. And the court then says, and I'm ordering you to do whatever the mental health evaluator says you need to do.
We agree, and I think under this court's case law, that falls on the non-punishment end of the
So
spectrum.
I think that all makes sense to me. That the argument, I guess, here is that because of the way it was worded, in theory, the expert could conclude that this person doesn't need any treatment, that Bragg doesn't need any treatment at all. I'm guessing that practically, I know much less about this than my colleague Judge Hunt, but I'm guessing that practically speaking, that's probably would never happen. The expert would never look at this and say, oh, yeah, no treatment at all, it's fine. But in theory, the wording of the court's order here leaves that open, whereas I suppose in Reardon they could have reached the same conclusion, but they would have had to say, okay, you're in for sex treatment. You got 5 seconds, and that's all we think you need. That's why I'm saying it feels like semantics, but there is logically maybe a difference. And I can you confirm for me practically what are the chances that he would? If nothing else, you have an industry, right? And somebody whose job it is to give people treatment, and it seems weird for him to say, yeah, no treatment needed here. I just think that's my instinct is that practically that's not going to happen.
I don't know the answer to that. I would share your instinct, but all I know is that on the facts of this case, the treatment provider felt that it was still necessary to sort of give him another chance, even though he was refusing to answer questions, even though he didn't appear to be participating in the sex offender treatment.
You say another chance to participate in treatment?
Yes. That was what the probation officer relayed, was that, despite initially not speaking with the polygraph examiner, the treatment provider believed that, I think as the district court said, that the professional opinion was that he needs to continue to be in treatment because there's a mindset that needs to be addressed. So
And then the
it's hard.
district court looked at his criminal history and said, that's the mindset I'm trying to change.
Correct. And one final point, we don't believe that it was plainly erroneous for the court to rely on the treatment professional's opinion. Basically, in order for this court to find error, it would have to show that that it was factually untrue or unreliable, and that there was not even a minimum indicia of reliability. Here, this was a professional treatment provider providing his or her opinion about what was best for the defendant, and there was nothing wrong, certainly nothing plainly wrong about the court relying on that when determining what conditions to impose.
But you don't dispute that the question of whether there's a delegation problem is reviewed de novo, correct?
Correct. He challenged that in the papers.
Right. Do you have any other questions from my colleagues?
No.
All right.
Thank
Thank
you.
you, government. Put 2 more minutes on the clock for you, counsel. Maybe you have, I don't want to take too much, I'll make sure you have plenty of time to say what you want to say, but is my instinct correct that the odds that a evaluator here is going to say, yeah, I've looked at and no treatment necessary for this guy, that seems like that would never happen?
That was argued in the lower court, that there's a financial incentive for the evaluator to recommend treatment. And then I heard Your Honor say this is an industry. That's what was argued in the lower court, is that there's a financial incentive to
maybe there's
to order treatment every time.
But my point about that is that even makes us feel even more just a semantic difference. If the difference between a judge saying you will receive treatment, the details will be filled out by the expert, versus you will receive treatment if the expert thinks you need treatment, or you need to talk to this expert and get whatever treatment the expert thinks. That latter problem being technically maybe a delegation problem, it feels very semantic if in almost every instance, and particularly in this instance, the treatment provider is going to set up some sort of treatment. Their recommendation is not going to be no treatment at all.
I think I don't have statistics or anything and we certainly don't have it in the record, but I think you very well could have an offender, and I'm thinking of a case that I was reading for a different matter. It's not going to come to mind, but where the defendant had a child porn offense and had it might have even been from another circuit, but had that exact thing happen where, despite what you would expect from the offense, sex offender treatment wasn't recommended. And I don't know that the court can fairly conclude that wouldn't happen.
So maybe my instincts are, but that does lead me to feel a little bit like a catch-22 for you. But it does lead you to, if that's possible, then it does seem all the more odd that we have judges saying you must receive treatment, and the details will be filled out by that person, by the expert. But when the expert gets it, they're like, well, I've been told by a judge, that we have to do treatment, so I guess we'll do it. But the expert doesn't, who actually knows a lot more than the judge, doesn't actually think they need treatment. The whole delegation problem here seems like some people on the Supreme Court or really smart people came up with it, and it doesn't seem to make much practical sense to me.
That may be. I would contend that it is an issue here where it's left up to the treatment team and the probation officers through them. One thing.
How is this any different from somebody saying, I want you to do what the doctor orders?
I think that.
Take the pills, go to the counseling, get treatment.
And
that's my order.
And that to me feels like the same delegation problem.
But it's the court ordering the defendant to comply with what the doctor prescribes.
Right, and in that choice of what to prescribe,
you really do want the judge.
You want
the judge to say, "Well, I know that's what the doctors don't know. I do. I'm the judge."
What I would propose as the right way to do it is there's a report, an evaluation. It comes back to the court. The parties have an opportunity to read it, and I recognize that the objections in the lower court did not properly preserve all of these issues. But then the court and the parties can review the evaluation and scores on tests and results.
The problem I have is it's just not a very practical suggestion. I mean, if we rule in the way you want us to rule, it's really going to throw a wrench in the gears of sentencing.
Counsel, to Judge Tallman's hypothetical, doesn't it matter in part what the doctor prescribes? So if the doctor prescribes inpatient hospitalization or this extreme form of plethysmograph testing, right? Undisputedly a significant restraint on liberty. Doesn't that make a difference when we want a judge to do that and not?
I would say yes. Under Esparza, we have the limitation on inpatient treatment, and then under Hohag, we have that comment from this court about the heightened restraint of sex offender treatment. This condition leaves open the door for the penile plethysmograph testing and those very invasive types of testing
But nothing prevents the defendant from coming back once that testing is recommended and saying, I object, they want me to take psychotropic medications. And we've got a whole line of case law that talks about that particular treatment and the restrictions on liberty and the due process concerns, and the court has to hold a hearing and all that sort of thing. Right? I mean, the defendant can always come back and challenge it.
I think from where we sit in this room, nothing prevents it, but I believe that there are practical realities, as we've been talking about, with the nature of the supervising probation officer and a defendant who doesn't have the power in that dynamic as far as actually getting themselves before the court to have it reassessed. I don't know that it's that simple for many of our defendants. Right, but getting from the stage of the treatment provider is telling me I need this, the probation officer is ordering me with its inherent coercion, regardless of how much they try.
The court's already ordered it. You keep trying to insert the probation officer, but in this case, it's pretty clear. The court said, I want you to do what the evaluator recommends you need to do after conducting the psychosexual evaluation. I don't see the delegation problem here. That is the order of the court, imposing the term and condition of supervised release.
My position is that it's only if.
I mean, we're back to
right.
Okay.
I don't want to do a with Your Honor with all respect. Yes.
Well, we've taken you way over. Do you have? But I want to make sure, and it's been a pretty hot bench. Do you have anything we haven't been able to
I
cover?
did want to respond to the government's point about it. The government appears to me to be arguing that it's limited to where there's punishment, but I believe some of the language of this court in Stevens makes it a little more broad than simply punishment. I would contend that even in Esparza, the inpatient drug treatment wasn't really punishment. It was an intensive form of rehabilitative treatment. And some of the language in Stevens as well that this court used shows that I don't know that it needs to be punishment for it to be a delegation problem. I think where we have an intensive supervised release condition like this, that's enough to have a delegation problem. So I just wanted to have that response. Thank you.
Any other questions from colleagues? All right. Well, thank you, counsel. I want to thank both sides. This case is submitted. It's a lot of questions, but very, very helpful.
Yeah.
Thank you, Your Honors.
Thank you.
Thank you.